We resume the debate on the draft Royal Court Amendment Jersey Law 2000. On my list, I had the Deputy of St Mary to speak next. Deputy St Mary.
Yes, sorry, Ma'am. Yes, my application to speak was before the call for a reference back, and what I said subsequently more or less covers it. The only point I wish to say, Ma'am, is, or to repeat, is that the proposition now before us is due to meet a particular situation. At the moment, Jorats are unable to retire before they're 72, and it was simply to incentivize the position, that it was felt by the retiring Jorats it would be helpful if that restriction was removed. I've noted all the comments made by Deputy Talley and others as to the need for a more wholesale review, and I personally accept that. I also accept that I didn't mean to say that it was an extreme view that advocates shouldn't participate, but I make the further point, if I may, that if the justification for advocates being involved in the process is that their frequency in court gives them the right credentials to determine who is best to be a jurat, then it should be taken into account the fact that a large number of advocates never actually appear in court, so that hopefully will be something to be taken into account. But to return to my basic position, Ma'am, it is that this proposition is made at the request of retiring advocates to meet a particular situation, and whatever the future holds as to more wholesale change in the situation, I see no reason why this proposition should not be carried forward now, and I shall be voting in favour of it. Thank you, Ma'am.
Thank you, Deputy. Senator Moore, I also had you on the list, but that may have been before the reference back. Can I just clarify, do you wish to make a speech now as well?
Thank you, ma'am. Much as the Deputy of St Mary, I think that during the reference back speeches, we touched upon all of the relevant points, and there would be no need to really reiterate those points at this point. But thank you.
Thank you. Does any other member then wish to speak on the principles? If no other member wishes to speak on the principles, Deputy Higgins.
Thank you, ma'am. Just to say, I was disappointed that the proposition wasn't referred back, and I find the fact that we are passing laws that are discriminatory unacceptable, and therefore, just to say, I should be voting against this proposition. Thank you.
Thank you, Deputy. Does any other member wish to speak? If no other member wishes to speak. Oh, sorry, Deputy Southern.
Yes, just briefly to agree with Deputy St Helier has just spoken. I too am very dissatisfied that what we appear to be doing, without any analysis or any justification or any sharing of what's permitted, we are passing discriminatory law, and it seems to me completely wrong. So I'm going to consider whether I vote against the entire package. I'm considering my position.
Thanks, Deputy. Does any other member wish to speak on the principles? No. No other member wishes to. Oh, Deputy Young.
Yes, just similar to other members who've just spoken. I don't think you have to go into it in detail. I can't think I can endorse the discriminatory nature of these this age discrimination within this, so I'm not able to support it, sir. Madam, sorry. Thank you.
Thank you, Deputy. Does any other member wish to speak on the principles? If no other member wishes to speak, then I call upon the Deputy of St Peter to reply.
Thank you, Bob. Well, that was exciting. Members have raised a number of issues outside the immediate scope of this, and as I've said, it's essential that we keep constitutional arrangements under review, as in the speeches from the Deputy St Mary and Senator Moore. And obviously I'm glad to hear the panel be recommended to its successors, and I accept what Deputy Sutherland says, that you know, the next Council of Ministers aren't bound by the previous one, but it must be for wider consideration the process should be undertaken. And I think from the tone of the Assembly, that's the will of today's Assembly. However, can we stick to what we're on? This amendment only deals with a limited set of changes to the legislations, and of the changes, I don't think members objected to them on their own terms. All this does is aim to introduce a more flexible system for a retirement. And as we've heard again from the Constable of St Mary, it is at the will of the jurats. They have brought that to us at their request in order to help them, I don't know how to put it better, provide a more flexible, diverse and better service to the courts of Jersey. So I don't understand why we are not accepting this and moving on. We've had this quite a distraction. The only real point has been the ages of 40 and 72. And I think the Solicitor General explained the rationale for both very, very clearly. My understanding is the minimum age is intended to ensure that the judge of fact has sufficient life experience to make a reasoned determination of a criminal case. And the maximum age reflects that the role of a juror can be a complex and stressful one, which requires significant mental effort. Neither minimum nor maximum ages are unique to the role of juror. Many jobs have such limitations, as the Minister for Home Affairs has indicated, and I believe we have restrictions with the Honorary Police over here as well. So I would just like to remind members that neither the maximum age or the minimum age jurors are actually the subject of this proposition. The discussion between the employment law and then human rights implications, again, I believe belong beyond the brief of this. The comments are noted and have to be referred to the Solicitor General and hopefully taken up in the next Assembly when this is reviewed. So with that, may I propose the principles and ask for the appel.
The appel has been called for. In a moment, the greffier will place a voting link into the chat channel of this meeting. Oh, sorry, I hadn't seen that. Deputy Young, you have a point of clarification. Are you willing to give way, Deputy St Peter? Deputy St Peter, you're willing to give way for point of clarification. Deputy Young.
Thank you, ma'am. The deputies in his closing speech said that the age, what the explanation given by the Solicitor General was that the age of 75 was set at the maximum age because that required a very considerable, for company exact words have said, mental effort. Does that mean his remarks saying that anybody in excess of that age is incapable of mental effort? So is that the explanation the members are asked to approve?
I'm not. Well, it's a matter.
Obviously, I can hear where the deputy is coming from. Wow, I'm going to have to use my best English here. I think the reason is that the cases that they're asked to sit, is the rationale being given, can be very, very, very long. And I think that is the consideration that they are taking into consideration. Having said that, it's not for me to determine it, and I suggest it is taken forward into the next Assembly and reviewed. Thank you.
Thank you, Deputy. Very well. The appel has been called for. Greffier will add a vote into the chat channel in a moment. The vote is now open. I ask members to cast their votes. All members have now had an opportunity to cast their votes. I ask the greffier to close the voting. I can announce that the principles have been adopted. There were 32 votes for and a further 3 votes in the chat, making it 35 votes for, 10 votes contre and 1 abstention.
May we have the 10 and the 1, please?
Greffier.
Those members voting contre, Deputy Ward, Senator Mesic, Deputy Young, Deputy Tadier, Deputy Doublé, Deputy Higgins, Deputy Southern, Deputy of St John, the Alves, Deputy Gardner, and the member who abstained is Senator Moore.
Does the Corporate Services Scrutiny Panel wish to scrutinise this matter? Senator Moore?
Apologies, ma'am. As mentioned, we will be placing this on our legacy report for a future panel to attend to.
Thank you. How do you wish to propose the articles, Deputy? Microphone.
I think we've discussed this at length, but if anybody wishes to ask any questions, I'll obviously endeavour to do them, but otherwise I propose we take it on block.
Are articles 1 to 5 seconded?
Yes, sir. Yes, ma'am. Sorry.
Does any member wish to speak on the articles? Deputy Young.
Can I exercise I think it is a right to ask for Article 3 to be taken separately, please. That's the one with the age discrimination. I've no objection to Guernsey Durats being coming in, and I've no objection to removal of this clause about the Church of England and women's science. That's a sensible thing, so I don't want to vote against those.
Thank you, Deputy. And yes, it's absolutely within your gift to ask for the articles to be taken separately. Does any other member wish to speak on any of the articles? Deputy Tadier.
Thank you. I think it is worth talking on some of the articles, in particular. Deputy Young just mentioned that he doesn't have a problem with Guernsey Durats being called upon in Jersey, and I know where that's coming from emotionally, because of course Deputy Young, more than anyone else, is a pan-Channel Islander, and I think it's important to say that we should be working more closely with all of the other Channel Islands, in particular Guernsey, and it's not something that we've cracked. But there is a constitutional issue here, because whilst it is common for us to ask, or the court rather, to ask for commissioners to come in on occasion from other parts of the British Isles and from the UK, and you could argue then what's wrong with doing that with Durats. It does bring into question again why we have an electoral college system which the Guernsey Durats are not liable to. We're effectively having Durats who are elected by another jurisdiction being called upon to serve in our jurisdiction. Now we wouldn't do that with states members. We wouldn't say, oh, you know, the Constable of St John or whoever, for want of a better example, talking about the role, not the person, can't be here. Maybe they've got a long-term reason for not being in the Assembly. Let's just get one of the states members from Guernsey to come and fill in for him or her, but in the case that it was a her, it would be ludicrous, because that person wouldn't have any mandate, any legitimacy to serve in our assembly. And so it would be fine if we had a different system whereby jurats were appointed, whether they would be Crown appointees or directly rather than being elected, or whether they were appointed by an appointments commission or panel, because that would make sense. But the fact is, it doesn't make sense to have the two systems coexisting. So again, I can't be supporting the allowing Guernsey jurats to come and serve in Jersey, not because I have a problem with Guernsey jurats or a problem with their capability, but simply because it is incompatible with the current system that we've got. It is ironic, of course, that the thing I do have a problem with is the current electoral college and the way that jurats are elected rather than appointed. But because of that, in order to follow the workings through like a good mathematician, I have to therefore come to the conclusion that we shouldn't be passing things that are incompatible with that system we've got. I'd very much like to know what the thoughts are of the Deputy of St. Peter in that particular regard, to understand whether he thinks there is indeed a tension between the electoral college system and the fact that Guernsey jurats are not elected under the Jersey electoral college system. And if it's not a problem, could he explain why it isn't a problem for him? So with this in mind, I'll also be asking for all of the articles to be taken separately. Thank you.
Sorry, Deputy, just to clarify, you're wanting each article to be taken as an individual vote? Each
Yes,
of the 5?
please.
Okay, thank you. Does any other member wish to speak on the articles? No other member wishes to speak. I close the debate on the articles and call upon Deputy of St. Peter to reply.
Obviously, thank you, Mark. The request from Deputy Young has been surpassed, and obviously we will respect Deputy Tadier's request to take each article separately. I mean, drawing in something that's beyond the brief of this, in my opinion, the brief of this proposition, and that's to the workings of the Electoral College. And I have to stay. The reason we have this, and it's a very rarely used provision. I'm talking about the jurats from Guernsey now. A very rarely used. I haven't got the numbers to hand, but it's very rarely used. And when I asked about it and what it meant, the words came up with things like only used in an emergency, a mass lot of Jersey jurats. Or more importantly, some of the jurats are conflicted or perceived to be conflicted in dealing with a particular case. And I see this as merely resilience to our courts to ensure that in these exceptional circumstances, we have an opportunity to call on skilled people from elsewhere to supplement and ensure our courts continue to work. It is a way that has been sought out. It appears to work. It's very rarely used, but I don't believe really any more than that it's part of this amendment. So with that, Ma'am, may I propose the principles and ask for them to be taken 1, 2, 3, 4 and 5?
The articles, yes. So the first vote will be on Article 1. In a moment, the graphier will place a voting link in the chat. Apologies, we're having some technical difficulties.
Ma'am, could I ask for one and 5 could be taken together? I don't see those as controversial, but if it's already in train, then obviously leave it as is.
So Article 1 and 2, you're happy to be taken together?
No, I was going to suggest 1 and 5 because I think I don't know if that's possible.
Can't really do it that way, Deputy.
Okay.
We have to do it in order.
Thank you.
The link is now in the chat. Members wish to cast their votes. The vote is in the chat. All members have had an opportunity to cast their votes. I'll ask the greffier to close the voting on Article 1. And I can announce Article 1 has been adopted. There were 44 votes in favour and 1 vote contre and no abstentions.
Could we have the contre, please, ma'am?
Can we hear the contre, please, greffier?
Member voting contre, Deputy Southern.
Allow us some time to reset the system. And in a moment, the greffier will place the vote in the chat for Article 2. Vote for Article 2 is now in the chat. We can invite members to cast their votes. All members have had an opportunity to cast their votes. I'll ask the greffier to close the voting. Article 2 has been adopted, 42 votes pour and 2 votes contre. In a moment, the greffier will place further vote in the chat for Article 3. Vote is now in the chat. Can I invite members to cast their votes? All members have had an opportunity to cast their votes. I ask the graphier to close the voting. I can announce that Article 3 has been adopted. There were 32 votes for and 11 votes contre and no abstentions.
Have the 11, please.
We have the 11 contre, please, graphier.
Members voting contre, Deputy Young, Deputy Doublé, Deputy Ward, the Connétable of St Martin, Deputy Southern, Deputy Tadier, the Deputy of St John, Deputy Gardner, Deputy Ash, Deputy Alves, and Senator Mezek.
In a moment, the graphier reset the system and place a vote for Article 4 in the chat. Vote is now in the chat. Can I invite members to cast their votes? All members have had an opportunity to cast their votes. I'll ask the graphier to please close the voting. I can announce that Article 4 has been adopted. 40 votes for, 5 votes contre, and no abstentions. And the final vote, graphier, for Article 5 to be placed in the chat, please. Vote is now open. I ask members to cast their votes. All members have had an opportunity to cast their votes. I ask the graphier to close the voting. I can announce that Article 5 has been adopted. 44 votes for and 2 votes contre and no abstentions. Do you wish to take the matter in third reading, Deputy?
Before I do so, may I please thank the officers, everybody who spoke, some very valuable contributions, and hopefully listen to the jurettes, and hopefully we'll be happy with this if obviously the third reading is successful. I'd just like to make one comment to Deputy Tadier. He implied I took his challenges with disdain. I certainly did not. I know he is very passionate about this subject. All I was trying to do was to stay on track and keep focused on the amendment at hand, and not digress from that. However, I hope he doesn't feel that I dismissed his passion. I certainly had no intent to do so. And may we please take them on block?
There's no need. It's just a simple vote on
Sorry?
third reading. It's just one vote on third reading. Yeah. Does any member wish to speak in third reading? Deputy Tadia.
Thank you, sir. So without splitting hairs, it's not that I thought the rapporteur was treating me with disdain. I meant contempt in the sense that he's still not fully addressed, I don't think, the underlying points. And it's that there are key areas that we passed as an assembly today in the law which are entirely salient to the proposition, because they are in the amendments that have been passed. And so, of course, as this is a third reading, it is incumbent on all members to think about the entirety now of what's in front of us. And if there are still areas which members have concern over, bearing in mind it will be for a future assembly to consider any future changes, I think now is the time to put the concerns on record by the way we vote accordingly for or against. If members think that this law, the discrimination that goes into it, is all fine, then so be it. I would say that the age discrimination has no place, and that in fact, if you want to guarantee that the candidates who are ultimately elected as or appointed as jurats are fulfilling of certain criteria, then it's important to just have those criteria in the job description so that the Electoral College can consider them. There may, of course, in the future be a very capable 38-year-old or 25-year-old or 80-year-old who is quite capable of doing the job of jurat and fulfilling the multiple roles that they have, and they shouldn't be excluded from doing it simply by a prescriptive and discriminatory law, sir. So I hope that those arguments won't have fallen on deaf ears, even if the changes aren't forthcoming in this particular iteration of the amendments. And just to make sure that the Deputy of St Peter knows, we haven't in any way fallen out over this. This is just the normal bread and butter for us in the Assembly. And next time I cross him on my dog walk, I'll still say hello to him.
Deputy Higgins. Deputy Higgins, you indicated a wish to speak.
Sorry, ma'am. It's as I was about to click the button to speak, a little tag obscured the microphone. I just wanted to say that, first of all, to explain, I missed one of the votes on the articles. I had to race off for a comfort break, but I would have voted against. I just want people to know that. I'm going to be consistent. What I want to say here is that I think it's wrong that the state is passing legislation that is discriminatory. That's number one. And number two, again, just raising an issue that Deputy Tadia mentioned as well. The jurats, bringing in jurats from Guernsey. Jurats are not legally trained people. All they are lay members of the court. They're there to determine on the basis of the facts. It is the bailiff or the other judges who sit with them who are the legally qualified people who give advice, but they are judging the evidence. Why cannot we have Jersey people who could be brought on rather than to have to import people from Guernsey who, other than the fact they may have sat in another case, have no particular qualifications they're going to bring to the issue? So to be consistent, I should be voting against this proposition. Thank you, sir. Ma'am.
Thank you, Deputy. Conatable St Brelard.
Thank you, Madam. I think this is a good time for be to thank all the jurats who give so much time to the role we've been discussing over the past few hours. And I think a lot of members would agree with me that it's a tremendous job. I think it's an attractive job for those with interests. We have specialisms within the benches of jurats, and I, for one, am most grateful for all they do free of charge. Thank you.
Thank you, Connetable. Deputy Young.
Yes, sir. I think, ma'am, apologies. I need to put on the record, ma'am, that I think, having listened to Deputy Tadier, I think he is right. That I don't think we should be passing a law with such discriminatory provisions in it. But having said that, I absolutely agree with the Connétable of St Brelade. I have the highest respect for people who have served and served for many years and given huge amounts of time for it. I think my concern is about that. I do worry about this is a law we're asked to pass that includes discriminatory provisions which are contradictory to the way we're modernising society with social reform throughout. And of course, this is going to go, when this is approved, this will go to the Privy Council. And so we will be advertising in that vital British jurisdiction that this is what we do. And I think, frankly, to be honest, I think it was a mistake to do a sort of a fire, a sticking plaster amendment. It would have been better to try and bring the priorities through and bring forward a change in the arrangements which would deal with the issues that we've spoken of. But I think this issue now of the age discrimination, which is, frankly, I cannot see any of the reasons given stand up. They are arbitrary. And I really, madam, I just think I want to put that on record. But in no way is there any disrespect for any of our jurats. They are absolutely incredible commitment they've given. And of course, I have to be honest. At my age, well, I wouldn't be allowed to be anyway. But at my age, I couldn't do that. I think it's above and beyond for them. But nonetheless, I think we do need to change for the future. And if my putting a vote against it helps speed up that work, then I think there would have been a point in my doing what I have taken the position today. Thank you, ma'am.
Thank you, Deputy. Does any other member wish to speak? If no other member wishes to speak, then I close the debate in third reading and call upon the Deputy of St Peter to reply.
I think it's important that thank you. I think it's important that the messages put on record by Deputy Young and Deputy Higgins are acknowledged and taken forward. I'd just like to say I look forward to seeing Deputy Tadier on a Sunday morning when we often bump into each other, and I look forward to seeing his dog again, a charming little creature. But most importantly, I'd like to echo what the Councillor of St Brelade said, that our jurats do a wonderful, wonderful service for this island. And anything I feel we can have done today to help that is a day's work well done. May I call for the bell? Thank you.
Very well, the appel has been called for. In a moment, the greffier will place a voting link in the chat of this meeting. The vote is now open. I invite members to cast their votes. All members have now had an opportunity to cast their votes. I ask, give it a few more moments. I notice a message in the chat about it's taking a little while to load. I Now ask the greffier to close the voting. Senator, I note in the chat that you've misvoted, but obviously we cannot change that vote. I can announce that the law has been adopted. There were 38 votes for and 1 vote can't, 6 votes can't and 1 abstention. Actually, I'll call it 39 because I think Deputy Pershard, your vote came in at exactly the same time as the Assistant Greffier posted up the announcement. So that's 39 votes for and 6 votes can't and 1 abstention.
May we have the 6 and the 1, please, Mark?
Greffier.
The members voting contre, Deputy Doublé, Deputy Young, Deputy Higgins, Deputy Southern, Deputy Tadier, and the Deputy of St John, and the abstention, the Connétable of St Martin.
Very well, the next item is the proposition tenancy notice period, P2, lodged by Senator Mezek, and I ask the greffier to read the proposition.
The states are asked to decide whether they are of opinion to request the Minister for Housing and Communities to make an order under Article 6(3)(e) of the Residential Tenancy Jersey Law 2011 to introduce increased minimum notice periods for periodic tenancies where the tenant has lived in their home for a long time.
Senator, there's an amendment lodged by the Minister for Housing and Communities. Are you accepting that amendment?
I'm not, sir. No.
You're not. Very well. Then I call upon you to make the proposition.
Thank you, sir, and welcome back. So with this proposition, I'm asking members to request that the Housing Minister uses powers he has to enhance security of tenure for the potentially thousands of islanders living in their homes on periodic tenancies, to provide them with extra notice if they're required to have their lives upheaved by being told to leave their homes that they've lived in for so long. As an appendix to this proposition, the example of how this is done in the Republic of Ireland is included, which gives an idea of what sort of thing we could be looking at here. It's basically just an extra few months' notice for those tenants who would otherwise suffer the greatest inconvenience by virtue of the fact that they have become most settled in those homes that they have lived in for years. So just to assist members in understanding what a periodic tenancy is, a periodic tenancy is a tenancy which doesn't have a specified end date, but which can be unilaterally ended at any time without any reason, just by the landlord giving 3 months notice or the tenant giving 1 month's notice. That's different to a fixed term tenancy, which is a tenancy that does have a specified end date, which is the only point in time in which it can be ended. So it is the case in Jersey that people can live in their homes for years and years, potentially even decades, as renters, and still only be given 3 months to leave, even if they haven't done anything wrong whatsoever, and there is no appeal. That can mean turning someone's life upside down. This can be people who have been very happily settled in their homes, have put a lot of effort into making the property they live in feel like a home. They may have children in the local school. They may have caring responsibilities managed on the base of their location. Their whole lives developed around the location in which they live in, which can be of such fundamental importance to them. And that lack of security is a really big deal for lots of people in their lives. The fact that they can simply be issued 3 months notice at any point and that's it, they have to go, irrespective of what the alternatives are or how difficult that may be. And I make the point, sir, that almost everybody in this chamber lives in a home they own, and the voice of those who live with this insecurity in that form of tenancy arrangement is completely missing. So in comparison to other nearby jurisdictions, tenants in Jersey actually don't have very good rights to enable them to live comfortable lives. There are jurisdictions very close to us where there are much stronger rights in place for tenants when they are renting a home to be able to live there, to build their lives around that, without being told they have to go without a good reason. And of course, legislation in those other jurisdictions outlines what those good reasons are so that they can be reasonable. And so because we're in a worse situation, I welcome the comments that have been made by the Housing Minister recently about him signing off law drafting instructions for reforming the residential tenancy law. That is good news. And he's mentioned it a few times, including in the previous debate on the rent safe scheme. But we haven't actually really heard much detail of what is proposed, what he has actually signed off to be looked at by the law drafters. I was castigated in the previous debate by the Assistant Housing Minister, who pointed out that the ministerial decision is on the government's website, and so it is, and I've got it up on my computer in front of me. It talks about some good high-level things, but it doesn't provide any detail really on what will be included in that law. So I guess I'm giving notice to the Housing Minister that when he speaks to his amendment, I would like to hear him give greater clarity on what exactly it is he's asking to be done to improve security of tenure for those people. To say we want greater security of tenure is good, but what? Specifically what? Is he talking about European style open-ended tenancies, for example? I'm interested to know if that is what he's told the law drafters to look at. Is he proposing some of the other measures that were included in the Housing Policy Development Board? Let's hear it. And if he's got a good case to make there, then I'm all ears for it. But it's not fair to ask members to reject a proposition which is clear and tangible in what it's seeking to do, in deference instead to an unclear and intangible proposal for the future, especially when it is so far down the line and we're talking instead in this proposition about doing something imminently. The Housing Minister's amendment and report are very disappointing, and they make a number of points which are invalid in my view, and I'll address those points when we come to the debate on the amendment. But the one that I did want to deal with in my opening proposition speech is to say the very first comment in them does stick in the teeth quite a bit, calling this proposition knee-jerk, because it isn't. I make in the report to this proposition a passing reference to the situation at Spencer Close because, and only because, it serves as a useful case study, and perhaps it was a mistake for me to have mentioned it, but it's not the reason that security of tenure is on the agenda, because moves to enhance security of tenure have been on my agenda since the very start of this electoral term, and it is a subject which a considerable amount of time and deep consultation has gone into, and that should be obvious to anyone who's been paying attention. And some examples of that, sir, I successfully bid for funding in the government plan, which the current minister has inherited, to undertake a project to overhaul the residential tenancy law. Members can go back to those previous government plans to see that very clearly in the charts there. So this is something which has been on the cards for a couple of years now. It's not something that has merely just been raised at the start of 2022. I also spent a considerable amount of time serving on the Housing Policy Development Board, which I was on with several other states members and ministers from all sorts of political persuasions, including several members who have gone on to form another political party. So perhaps retrospectively, we can call it a cross-party policy development board. and we considered the matter very deeply and made clear recommendations on security of tenure. And that was a big project. Lots of money went into it, lots of consultation went into it. So this issue of security of tenure is not knee-jerk. And following the Housing Policy Development Board's report, I then brought those recommendations to the States Assembly to be debated, where they were rejected. And so what I'm doing here now is coming back again to try to salvage something which at least takes us in the direction that all of the work done in this term says we ought to be travelling in. And it's to provide some action in the short term, whilst we keep our fingers crossed that some other good things are heading our way too, further down the line. So I'm proposing this because it could be a quick win. The Minister has said that the new residential tenancy law won't be available until the end of the year. Beyond that, it could take further months to go through the Assembly to be scrutinised. And if it's like the previous residential tenancy law, which was passed in 2011, but didn't come into force until 2013 to give time to people out there involved in tenancies to understand it and get used to it, then we actually could be looking at a situation where nothing is done to enhance security of tenure until 2024, maybe even 2025. So that's why this proposition is here, because having been set back several times in the work to make real progress on enhancing security of tenure, for some political reasons and other reasons as well, we can use the law as it currently exists in the meantime to provide extra support to tenants out there who have been living in their homes for a very long time and who would suffer the greatest inconvenience at being required to leave their homes at what is relatively short notice. 3 months is short notice if you've lived in your home for years and years. It might not be if you're somebody who is still settling down in life and does frequently move between properties, and the flexibility is of advantage to you. But if you're someone who's trying to raise a family, it's not. If you're someone who's trying to raise a family and get told you just have 3 months to totally overhaul your life, perhaps move somewhere that is much more unaffordable for you, or where you can't, where you're not able to find somewhere that's nearby the school to do an easy school run for your children, and so have to do a much more difficult one. If you're not around those with whom you rely on for support, for caring, and all such other things, it's a really big deal. And so passing an order which sought to do what is already the case in other jurisdictions, and the Republic of Ireland being the very key one here, which simply says if you have lived in your home for a number of years, your notice period gradually goes up. We're not talking drastically going up. We're not talking about saying to landlords you can't empty your homes for years if you have a long-standing tenant, but to say that 3 months is a bit of an ask for some people, and actually maybe closer to 6 months or 7 months even for those who have really lived there for a substantial amount of time, provides them with a bit of cushion, which could go a long way for them given the difficulties there are right now for many people who are trying to find new homes, and for those who in recent months have suffered by being given the bare minimum notice that is required. So, sir, this proposition doesn't in any way seek to undermine the work that is due to go on to enhance the residential tenancy law. It's a good project, one that I wholeheartedly support, and one which I was happy to do at least a little bit to help lay the foundations for, so that it could go ahead. But it's to acknowledge that that will take a long time to bed in, to be approved, and then for people to get used to its provisions and then become commonplace out there in the rental market in Jersey. But to say in the meantime, recognising how difficult things can be for some people, and recognising the stress and difficulty it can cause for a short period of notice to be given to people who have lived in their homes for potentially decades, we can do one little thing to make things a bit easier for those people, and we can do it relatively soon. We can do it before this term of office is out. The Minister does have good examples that he can refer to implement relatively quickly. So let's give a green light to that and say, let's do at least one small thing to enhance security of tenure now, whilst the greater work goes on as well. So on the basis that this seeks to make a positive difference for those people now and doesn't detract from other work going on, I'd ask members to support this proposition unamended, and we'll obviously come to the debate on the amendment momentarily, and I'll seek to make the case early on in that debate for why the amendment should not be accepted. So I make that proposition, sir.
Much the proposition seconded. Deputy Young, you've asked for a question for the Solicitor General. May I suggest it might be more appropriate after the proposition, after the amendment has at least been proposed, and therefore the Solicitor General can advise in the light of everything before the Assembly?
Yes, sir. Sorry, I put it in the wrong place. So I should have waited for the amendment.
Very much. There's an amendment lodged by the Minister for Housing and Communities, and I ask the greffier to read the amendment.
For the words "to make an order under Article 6(3)(e", substitute the words "as part of his current modernisation review", and for the words "to introduce increased minimum notice periods for periodic tenancies", substitute the words "to bring forward proposals to improve security of tenure protection".
Minister.
Thank you, sir. Well, yes, I agree with an awful lot of what the Senator was saying in his speech, of course. Apologies about the knee-jerk remark. I say to the Senator, I thought this came out as a direct response to a recent incident, and I certainly didn't mean to be derogatory, so I hope he accepts that apology. This boils down to two very clear things in my opinion, and that's why I put in the amendment. I notice that the Senator in the press called it a wrecking amendment. I disagree. I think actually, in fact, the potential for wrecking lies with the main proposition. I do not believe that the proposition will actually improve the rights of long-standing tenants, and it runs the very real risk of making things worse for them. And it's not democratic. I do not believe that ministers should act in an autocratic manner and use order-making powers to change policy without proper consultation. My amendment addresses these points. I've already taken action to update the residential tenancy law. On completion of law drafting, a full, meaningful consultation will be launched. The next States Assembly will then be able to take an informed and democratic decision as to the details of the new law. We will ensure that changes to the law provide for a fair rental market and do not create loopholes and unintended consequences. The fundamental problem with the Senator's proposition is that it only makes one change to one type of tenancy. It only impacts on periodic tenancies, that is, tenancies that don't have a fixed end date. For that type of tenancy, the proposition would create a longer notice period for long-standing tenants. But under the current law, there is nothing to stop the landlord changing a periodic tenancy into a fixed-term tenancy. This would give the tenant less security of tenure, make it less likely that a tenant can stay in the same home for many years. And the current law only applies to tenancies that started after 2013. So for some long-term tenants, the Senator's proposition is irrelevant anyway. I understand the Senator's motivation, but this proposal does not stand up to external scrutiny. Last week, I signed a ministerial decision to initiate law drafting on the new residential tenancy law, as we've spoken about already in this session. The new draft law will be widely circulated for discussion and consultation with landlords and tenant groups and other interested parties to make sure that it provides a good legal foundation for a fair rental market. The new draft law will include new provisions for notice periods, but that will need to be backed up by other protection for tenants to avoid the loopholes such as those that I've been describing and that are in the Senator's current proposition. That work I have already commissioned is looking at local and international examples of best practice, including the Irish example, to ensure that we produce a modern and comprehensive legal framework that will create a fair rental market. The new RTL seeks to widen the scope of the existing law to include a greater range of properties and tenants, increasing tenants' rights and creating a more level playing field for landlords. Amending the types of tenancies which are available and enhancing provisions around the length of notice periods for different types of tenancies will allow flexibility in tenancies to remain, but also strengthen tenants' rights, particularly where they have lived in a property for a long period. I aim to expand on and clarify provisions relating to investigation and enforcement of the law and situations where the court can act. Included within the proposal are suggestions to expand the list of definitions, interpretations for terms such as lodger, boarder, peaceful enjoyment of properties, uninhabitable properties, sublets, and similar. Roles and responsibilities of all parties to an agreement and charges made at the time of signing tenancies will be clarified and guidance offered. There are about 25 new articles or redrafted articles in the new residential tenancy law. It's a big piece of work. So I've tried to explain in the report that accompanies my MD what our new RTL aims to achieve and also the scope of it. Now we have to do the detailed law drafting, and I think it would be wrong to publish the LDIs now because this is still policy in development and it needs that time. And I think I have the best experience I have of intimately working on law drafting was with the electoral reform changes, and that was months. We used to meet every week, sometimes more than once a week when we needed to. Met the law drafter, who was absolutely brilliant, and she would always have a massive series of questions for us each week, which we would go through. It was actually painstaking, and the law developed. We hit hitches, and you have to work them out. It's a big piece of detailed work, and I want to complete it so that the whole picture, when it is published, is available to all parties to take a look at, rather than set the hairs running with one piece of policy that is released without being fully thought through. So to sum up, I understand the Senator's motivation for this proposition, but I cannot support it as originally drafted. The proposition runs the very real risk of reducing rights for tenants rather than improving them. I've already started a major programme to completely revamp the legal protection for tenants and would ask members to support my amendment to allow this work to continue without delay or distraction. So I'm not bringing this amendment to be difficult or obstructive. The Senator and I are on the same page 98% of the time. But I have very real, very genuine concerns of the unintended consequences of this proposition being approved unamended. And I think it would be a failure in my duty if I were not to make that plain and clear to the Assembly. Thank you, sir.
Much is the amendment seconded?
Seconded, sir.
Senator Mezek.
Thank you, sir. And if I may say to the Minister, what he has just given is a speech that, though I disagree with its conclusions, is a speech that would have been a perfectly acceptable speech in opposition to my proposition It's not a great speech in support of an amendment to the proposition, though. The Minister was right. I have described this as a wrecking amendment, and I stand by those words. I don't use those words to be emotive about it. I describe it as such for technical reasons, sir, and it's something you and I have discussed before and may well discuss again at some point in the future, which is the reason that I'm disappointed with this amendment is that it attempts to do what other recent government amendments to backbench propositions have sought to do, which is to turn it into a proposition which actually has no effect. So rather than having a fair fight and face a debate down on my proposition, the attempt is to amend it so that it does actually nothing. And I think what gives it away actually is the wording in the third paragraph of the report to his amendment, where he says, I ask members to support my amendment, which acknowledges the significant work which is already underway. And that's the key word there, acknowledge. We're being asked to acknowledge the work which is already underway. Also, why does this assembly need to have a debate to acknowledge something? If a minister is using powers that they lawfully have to pursue actions, to pursue policies, this assembly knows that they're doing it and no member chooses to contest it, then it is superfluous for it to come to this assembly for that approval, to ask us essentially to micromanage that approval, because the minister is perfectly free to continue with that work without a formal acknowledgement from this assembly. And I certainly had no intention of lodging anything to disrupt that project, not least because I helped lay the foundations for it. It's a good project. So what this amendment does, sir, is that it actually deprives this assembly of the ability at all to debate what I'm asking. I'm asking the states to have a debate on whether the minister should use the residential tenancy law as it currently stands to do a specific thing. This amendment, if it's accepted, means the states doesn't even get on to debate that very question, and instead it will debate whether we're okay with something happening that's already happening anyway. And I have to say, sir, I think that debate is a waste of our time. If we vote in favour of this amendment and then in favour of the amended proposition, nothing changes. If the proposition is defeated or it's accepted unamended, nothing changes. The work, as it's being done now, carries on. The minister is free to carry on as he is. So I really say to ministers, please stop doing this. It's not on. If you don't like a proposition, face it down and defeat it using the merits of your argument. Don't put in wrecking amendments to deprive the assembly of the opportunity to have its say and to deny the right of backbenchers to have their propositions heard. So if I bring a proposition and it's defeated on the floor of this assembly, then it's a fair fight. I'll be disappointed, no doubt, and I'll be thinking about what I do next, but at least it would have been a fair fight. But if this amendment is accepted, we don't even get to have the debate on it, and that's not fair. And I think ministers shouldn't do that, and the speech that the minister gave at the start would have been a perfectly acceptable speech in opposition to my proposition. So I disapprove of this tactic. The issue of the ongoing work on the residential tenancy law is a separate matter to whether we use the current residential tenancy law to achieve some change in the short term. One is a long-term issue, one's a short-term issue, and they don't detract from one another and should have been seen separately. And that, I think, is good enough reason alone for rejecting the amendment and getting on with a yes-no debate on whether we should enhance security of tenure now. That's the debate we ought to be having. But on to the actual points made by the minister, most of which I think can be countered. He's argued that the unamended proposition would cause unintended consequences, which would on balance be negative for tenants. And I disagree. And I believe the examples he's provided in his report are fanciful. Firstly, he suggests that when a landlord has had a good tenant for years and years, paying their rent, causing no trouble, that for the sake of theoretically an extra few months' notice, if the landlord wants to get rid of the person who's very kindly been giving them a big portion of their pay packet every month, that will be such a terrible inconvenience to them that they'll just empty the property and get rid of that tenant to preempt having to do this, which would lead to them having an empty property that's not making them any money, and it would risk them getting a new tenant who may not be as good as the previous tenants, because you would presume that the reason the tenant has lasted so long is because the tenant and landlord actually get on well with one another and are quite happy with that relationship. So it's taking one heck of a risk, isn't it, to say that somebody who you would hope you'd have had a good relationship with, if circumstances change and you do want to require them to leave the property, and there's lots of good reasons why you might want to do that. You know, you might want to move into that property yourself to live in, for example. That because you're being asked to be a bit more reasonable to them, that you'd preemptively get rid of them. I suspect most landlords aren't like that. I suspect that most would say, actually, fair is fair. If I have had a contractual relationship with you for so many years, which we both upheld and both been happy with, but it's going to cause you a lot more inconvenience than me to end this contractual relationship, do I have to be a little bit more generous to you in order that you can set up your life somewhere else a bit easier? I think most landlords would be okay with that. It'll only be the really worst ones who might choose to have a callous approach there. So I think it would really actually be cutting your nose off to spite your face, and it doesn't really make much sense, because the landlord has actually a lot more to lose than they do to gain in that situation. He says that it may encourage landlords to move away from periodic tenancies to fixed term tenancies, which he say provide tenants with less security. In some ways, yes, in some ways, no. There are advantages and disadvantages to periodic tenancies versus fixed term tenancies, but there are benefits to fixed term tenancies that periodic tenancies don't have. And the main benefit of them is that there is only one defined point in time where it's a possibility that a tenancy could end, as opposed to a periodic tenancy where it can end literally any time and can serve as a dark cloud hanging over the tenants as they try to live their lives. At least with a fixed term tenancy, you know what's what. You know you can't be kicked out, you can't have it sprung up on you as a surprise. It just means as you approach that point in time where the fixed term tenancy is due to end, you'll have to have a conversation at that point. You'll have to have a conversation with your landlord to determine whether you then go into another fixed term tenancy, at which point you then get the benefit of a protracted period of time where you can't be asked to leave that property. But also that provides you quite a nice opportunity actually to just have a conversation with your landlord and talk about your plans with one another. It may be the case that you're in a periodic tenancy and your landlord approaches you and says, actually, I'd like to have a fixed term tenancy with you. I'd like you to sign up to a year's tenancy. You might actually already be planning to leave in 6 months. And so that gives you a nice opportunity to say to your landlord, well, actually, I was thinking of going anyway in about 6 months. So how about we arrange it around that? And the landlord may say, oh, good, I'm pleased for the certainty there. That's helpful. Let's do that. Or the landlord may say, actually, I'm only intending to hold on to this property for another 1.5 years. So how about we do 1.5 years worth tenancy then? And then at least the tenant can sign up and can continue paying their rent, but knows well in advance that situation is going to change at some point for them in the future. And it's a good opportunity to just talk about other things that might need to be taken into consideration for the property, if there's maintenance or that sort of thing, because it is possible to have a periodic tenancy where you don't even communicate with your landlord for years, as long as you're paying the rent. And I certainly know people who have very little communication with their landlord, apart from the standing order that pays the rent every month. So actually, it's a good thing to have conversations, even if they are just to talk about what your plans are and to be upfront with one another. So there are advantages to fixed term tenancies. The biggest one being you don't have a dark cloud hanging over you all the time that you could lose your home at short notice for no reason. With a fixed term tenancy, it's only that defined moment in time, a defined moment which can be negotiated and can be understood and can be extended if you want to do that, that the tenancy can be ended as long as you're both obeying the rules. As long as you're both abiding by the contract, it can't be ended earlier. So I don't accept that this proposition will inevitably have unintended consequences which will make the situation worse for tenants. Most landlords will be perfectly reasonable about this, and it will probably actually reflect the behaviour they already undertake. 3 months notice is your minimum notice, but there's nothing stopping landlords from voluntarily offering greater notice. And if you have a long-standing tenant with you've got a good relationship with, you should be open and upfront with them to simply just to be kind to them. And I don't accept that it is automatically the case that fixed term tenancies offer tenants less protections, that there are ways that actually they can provide greater certainty to tenants, which some of them may find valuable. There's a slight double standard in applying that argument to this proposition, because the Minister has said that he intends this year to re-establish the Rent Control Tribunal. That is something which I support in principle, and I have myself brought a proposition to this Assembly to get the Rent Control Tribunal re-established. But what I did differently to the Minister is that I tied it to other measures as well. Pursuing that measure in isolation risks some tenants being subjected to revenge evictions if they try to use the services of that tribunal, because they'll only be required 3 months notice to leave if they're in a periodic tenancy. So if they decide to make a fuss, they can be kicked out and there's nothing they can do about it. So they'll either suffer or they probably just won't complain and won't avail themselves of this service. So if you're going to say that this is out of place because it doesn't come alongside other measures, that applies for his proposal for the Rent Control Tribunal as well, which I would warn him, I think is going to be a failure, at least in its early days, if it doesn't come alongside measures to enhance security of tenure. He ought to do those at the same time, and adopting this would actually increase the chances of the Rent Control Tribunal being more successful in its earlier days, because tenants will feel more empowered to stand up for themselves if they're facing unreasonable behaviour. He mentioned that this that this wouldn't apply to very old tenancies because of the residential tenancy only coming into force in 2013. The point does have to be made that if you're in a tenancy for over 9 years, it does have to be registered in the Royal Court. You actually have to pay stamp duty on it. And the residential tenancy law is a few months off being 9 years old. So those number of tenancies that haven't been captured by this they must be an extremely small amount, and in the very near future they're going to be zero, because it's been 9 years since residential tenancy law came forward. The Minister spoke about the law drafting instructions he's signed off, and I recognise the phrases he was using in his speech because it sounded like they'd been copied and pasted from the instructions themselves. But what is publicly available on that is not very detailed. It is still what we know about those instructions are still only his ambitions, his aims to achieve greater security of tenure. That's an ambition. It's not a statement of how you'll do it. And I did say in my first speech, I did ask him, has he issued instructions to talk about open-ended tenancies, for example, European-style open-ended tenancies is what I said, and he didn't answer that. He says it's policy and development. Okay, but I don't think it's fair to say to us, reject this clear and tangible proposition and just trust us that we've got the policy in development without telling us what it actually is. That's not fair. You do have to be clearer than that for us to have absolute confidence that what you're doing is the right thing, because it may turn out that the high level ambitions set out in that report we all like and we all sign up to, may be the case that the fine detail we don't like. And at this point, we don't know whether we don't like it because we've not seen it and the minister hasn't elaborated on it yet. So in summary, sir, I ask members to reject this amendment for the very simple reason that it is superfluous. It turns this from a debate into a debate from something clear into a debate on nothing, into a debate on acknowledging the fact that some work is already going on. And this assembly doesn't need to spend our time doing that because that work is going on. Nobody objects to it. Nobody contests it. Happy with it. Carry on, Minister. No problem. The assembly doesn't need to give its approval through an amended proposition like that. We accept it or reject it. It actually changes nothing on the ground, and that's not a good use of this assembly's time. Whereas a debate on the unamended proposition is at least a debate about something clear. And if the result of that debate is thanks but no thanks, we don't like this, then fair enough, that will be the assembly's verdict. But it might be the case that the assembly has listened to the arguments put forward by myself and the Minister for Housing and has decided on balance, whilst the ongoing work occurs, that a measure in isolation, as proposed in the unamended proposition, would do at least something good in the short term. They may actually want the option to say, small step forward in the short term, and we'll look forward to that bigger step forward in the long term. But by accepting this amendment, we don't even get the choice, and that's not on. I think actually there maybe ought to be a look at standing orders about these sorts of amendments that deprive the Assembly of an opportunity to debate something fairly like that. So the arguments he's made in opposition to what this proposition seeks to do is something we can come back to in the debate on the main proposition if the amendment is rejected. I think I've just made the case that it's not quite as it's not necessarily quite as he says it. There are two sides to this, and I don't think there is a serious risk about undermining security of tenure for tenants on periodic tenancies for the sake of just a few months extra help for them to find a new home that most landlords, I'm sure, would actually be pretty happy to give those tenants, given what a good relationship they've had and what a good financial favour they've done to them by paying their rent on time for so long. So, sir, I ask members to reject this amendment so we can have a proper debate on what my original proposition has asked us to. Kindly say to the government, perhaps try different tactics in future when it comes to these sorts of amendments so we can get best use of the time in this assembly. And let's instead have a proper debate on whether we take short-term measures to improve security of tenure for tenants, rather than simply give a green light to work that's happening already and that none of us have got a problem with. So I would ask members to oppose the amendment on that basis, sir.
Much. Is the does anyone else, any other member wish to speak on the amendment? No other member wishes to speak on the amendment? Deputy Hart.
So I wonder if I might ask my question now.
Yes, to the Solicitor General.
Of the Solicitor General. It's about periodic tenancies, sir. I wanted to ask the Solicitor General.
Yes.
I see that according to the article in the substantive law about that a periodic tenancy can happen or be created when a fixed term tenancy expires and the person remains in occupation. So I suppose where that leads to, can there be any differentiation of whether that situation occurs if somebody just carries on and doesn't give up possession at the end of a fixed period, or whether the landlord just doesn't get round to agreeing anything? I think that's important, because if there is to be an order, as is proposed, I would like to know whether an order prescribing a period of occupation can be varied according to the circumstances whereby the periodic tenancy came about. I'm sorry it's a complex question. The Solicitor General may want to think about it, but I think this question about unintended effects and periodic tenancies is quite important, sir.
Thank you very much, Deputy. Mr. Solicitor General, do you have any observations or able to help the Assembly at this time?
Yeah, so if the question is the initial one about what happens when a fixed term tenancy ends and how do you assess when that is, it seems to me the answer is this. If a fixed term tenancy comes to an end and the landlord does not, and the tenant remains in occupation, and the landlord does not seek to evict, then by default a periodic tenancy arises, and it arises from the point at which the fixed term ends. So that's the first answer. If it ends by agreement and by consent between both parties, it lapses or morphs into a periodic tenancy, then it can do that as well. And again, it would become a periodic tenancy from the point at which the fixed term tenancy expired. So if the question is how would one know in order to set or assess when a scale of notice period should commence, it doesn't seem to me to be necessarily a difficult task. One would wish to see what the fixed term tenancy expiry date was, and given that that agreement would have to be in writing under the law, it ought to be evidentially a fairly reasonably straightforward process to determine when the periodic tenancy began.
Thank you, sir. Thank you very much. Thank you.
Thank you, Deputy. Thank you, Mr. Solicitor General. Deputy Ward.
Thank you, sir. Just briefly, I wanted to just talk about the amendment and as a comparison, and then mention something. I looked up the ministerial order signed on residential tenancy law. The amendment, the original amendment, so I know we're talking about the amendment here, the original proposal, but in order to put it in context, I need to talk about the original proposition so I can make the juxtaposition between the two, if that's okay. I know we should be talking about the amendment.
Yes, I mean, obviously your main thrust will be whether the amendment should be adopted or not.
Of course,
but if you have to refer to the main proposition to justify that, that's...
Well, perhaps I'll make it easier by starting with the amendment. The amendment says to bring forward proposals to improve security of tenure protection. The original proposition has a very specific role to increase minimum notice periods for periodic tenants where the tenant has lived for a long time. So there is a very specific difference in the two. And the reason I mention that difference is within the ministerial order that is published, there is a paragraph that says from the summary of the review findings that says existing provisions around the types of tenancy which can be used and notice periods for different tenancies means that levels of protection for tenants and landlords can vary, leaving some tenants vulnerable to so-called revenge evictions and similar. There is currently no additional protection where tenants have remained in a property for a long period of time and tenancy agreements can be strongly weighed in favour of one party. Now, those are, I suppose I could say, sir, the words of the Minister from the summary report from the ministerial order. Now, that is a very specific identification of an issue around the protection for tenants who have been there for a long time and notice periods. The amendment, as worded, simply says bring forward proposals to improve security of tenure. I'm surprised that the Minister cannot just accept the original proposal, which addresses specifically increased minimum notice periods for periodic tenancies where the tenants lived there for a long time, because that's so specifically mentioned in the summary of the report. And what I think the original proposition is doing is addressing something that is in his own report, whereas I think what his amendment is doing, and I don't understand why that was brought forward, I have to say, is to just bring forward proposals. It's clear from that report what the proposals will be. They will be around length of tenancies and the length of time that people have been in those properties. I do sometimes feel so. I sit here and I'm trying to make a case, which is, I'm sure you're used to, but I'm trying to put these two things together. There is a logic to this from the original proposition that I think is lost with the amendment. And I would, even at this last late moment, saying with that in mind, I would say to the Minister, perhaps he needs to consider just forgetting his amendment and looking at the original proposition, because it actually addresses something specific in the summary that he has published and signed himself. And I think that's quite an important point to be made. Notwithstanding, you know, the limited data on rented accommodation, well, we talked about that earlier, and we're still not going to have that. And the notion, and it also says the enforcement of the existing law is further limited, given a range of investigatory, I can't say, enforcement and court-related provisions currently included. So those are the other issues. And if his amendment was dealing with those issues, I'd be saying, great, get on with those issues. But there's a whole paragraph there from the original proposition that's not being addressed by the amendment. And this might sound like a technical argument or perhaps a slightly pedantic argument, but I think it's a really important one. By watering down the proposition, it doesn't do what your own report is saying needs to be done. And I think that is mistaken. That's a mistake. And I think we can rectify that mistake by removing the amendments, going to the original proposition and looking at the summary of your report that you produced yourself and saying, well, it's clear this is what we have to do. Let's not waste any more time and let's try and make those improvements. That's all I wanted to say on it, really. But I think it's an important link between those two things. Thank you, sir.
Very much, Deputy Wall. Any other member wish to speak on the amendment? Deputy Taddy.
Thanks, sir. I had to look carefully at the actual amendment, because normally when an amendment is put in and you see the yellow highlighter pen, it usually is the case that the unamended proposal can still remain intact if you just remove the yellow highlighter pen. And what's happened here is that if you do that on the amended proposition, if you remove the yellow highlighter, so the full proposal as amended would read to request the Minister for Housing and Communities highlight as part of his current modernisation review, unhighlight of the Residential Tenancy Jersey Law 2011, and then another highlight to bring forward proposals to remove security of tenure, to improve security of tenure protection, end highlight. Now, it might sound strange what I'm saying, but whilst it's been possible from a word point of view to put that amendment in, it has broken up the clause that would have been there, because in fact the remaining words of the Residential Tenancy Law 2011 were in a particular context, and in the original proposition it was to request the Minister of Housing and Communities to make an order under Article 6.3e of the Residential Tenancy Law, and the important part of that is to make the order under Article 6 of the law, and the residential tenancy part is just obviously the context for the law in which that comes. So this is quite an unusual amendment in the sense that it isn't direct, and I can see why it's aggrieved Senator Mezek, because I think it goes further than would normally be permitted under standing orders for most amendments, in the sense that it seems to negate the actual, certainly the spirit, if not the actual technical nature of the proposition. I think Senator Mezek would agree with me on that. I know it's not his amendment. The minister might want to consider that. But the second point is that actually it's been worded in quite a clumsy way. So it is, if nothing else, tautological, the last part of the amendment, in the sense that there's unnecessary repetition. To bring forward proposals to improve security of tenure would have been sufficient, but it says to improve security of tenure protection. And I don't want to read too much into this, but it seems to me that once again, the minister, as the Council of Ministers are wont to do, are looking for excuses here to reject a perfectly reasonable, perfectly logical proposition, which falls in line with what the Housing Minister would want to do. Now, I have a feeling, I'm not sure, that the Housing Minister might feel that he's coming under fire from all sections of the Jersey community and from different sections of the Assembly where he previously thought he might have friends and allies. I'm sure he's still got the former. But really, he is making a rod for his own back if he can't work with the former Housing Minister, who's done so much of the preparatory work with the good staff and officers of his own department, and we should be heading in the same direction here. And this, the first way forward, I'm afraid, is the most simple. It's the obvious way to do it. And we can't keep having the arguments that are put forward, which we've heard again today, is that this is something for the next Assembly to consider. I'm afraid that just doesn't wash. We expect, and the island, I think, expects to have a government which can make changes now. None of us knows whether we'll be in the next Assembly, apart from, of course, those who know for sure they're not standing. And we are here today to make changes that we can, and to ask the Minister to make changes that are within his power to make sensible improvements for tenants in our island, also that give clarity to both tenants and landlords. And what is being asked for when you compare it, because we can compare the unamended version with the amended version to see which is best. And if it is the case that the unamended version is better than the amended version, then we have a logical and a political duty to go with the former. That's what I think is the case, sir. I think it's quite simple to request the Minister for Housing and Communities to make an order under Article 6.3 of the Residential Tenancy Law to introduce increased minimum notice periods for periodic tenancies where the tenant has lived in their home for a long time. The Minister can make that decision without the amendment, and he will still be able to direct the policy in whatever way he wants and word the article as he wants to use that power. So I ask him to get on and do it, and to start working with the former Housing Minister and not seeming to have to fight him on every turn, sir.
Thank you very much. Deputy Senator Moore.
Thank you, sir. The words inclusive government were just ringing through my head as I listened to both speeches of, the Reform Party members. They have all spoken very well and stated their case very clearly, but if I could perhaps elaborate on particularly the timing points that Deputy Tadea was just making there. It seems to me that this is just another government attempt to kick the can down the road and cause delay, and also avoid engaging with the concept of inclusive government and failing to respect the wishes and of members of the Assembly at large to represent their constituents and bring forward suggestions to improve the lives of the people of Jersey through this debating chamber. So essentially, this is a short-term versus long-term question. What I would suggest is rejecting the amendment for the reasons Deputy Tadea has laid out, but also if we think back to the debate of earlier today, much was made of the fact that the Housing Minister has recently lodged his law drafting instructions for a new residential tenancy law. Of course, he's done that just before both this and the earlier debate on the rent safe scheme. So why did he do that, knowing that these two debates were coming? And why has he made this amendment, knowing or suggesting that the changes would be in his proposed new residential tenancy law in any event. So I could, my advice to members would be to reject the amendment, because the intention of the amendment should be in the minister's new law drafting instructions in any event. And if members feel that they would like to achieve something in the short term for tenants, then they should, of course, be supporting the substantive proposition brought by Senator Mezek, which, as he has already laid out very clearly, gives the minister order-making powers to make a difference in the short term before the new law is brought. And of course, that is going to be someday, sometime down the road. Thank you, sir.
Thank you very much, Senator. Does any other member wish to speak on the amendment? No other member wishes to speak on the amendment? Then I close the debate and call upon the Minister to respond.
Thank you very much, sir. I'm really very surprised at the way this debate has proceeded, in terms of the time we've been spending talking about procedure. Sorry that Senator is unhappy with the amendment. I thought that was a polite and reasonable thing to do. We're talking about the last speaker. To my knowledge, there is, and here I am back in the Assembly, effectively on oath, to my knowledge, there is zero link between the Senator's proposition P121 and the Senator's proposition P2. There is zero link between those two propositions and the new residential tenancy law and the arrangements for the LDIs. I don't know if I can't, I can't be clearer than that. I don't know what Deputy Ward lost me. I'm very happy, Deputy Tadger, to work with Senator Mezek anytime. And but he doesn't like the amendment, but he has brought a proposition asking me to do something I'm already doing, but I want to do it in the right way. We're talking about procedure. I think we're on the brink of potential disaster for some people. The Senator's speech was full of might. This might happen, that might happen. I suspect this, I suspect that. He used the phrase, the landlord may say, a number of times, 2 or 3 or more. We don't know what is going to happen if I have to make this order. But I suspect we do know that tenants' rights under the current law are very, very weak. They are vulnerable. We also know that there is a lot. We also know the vast majority of our landlords are excellent, very good landlords, and we want them to continue being so. But even some of them are absolutely fed up with this government and ready to chuck the towel in if they get any more monkey business from us. And I'm afraid this isn't right, because we're bringing something in without consulting them. Look, I'm telling the landlords, we're going to increase tenants' rights. That is a fact. But we are also going to balance that with making things better in the new residential tenancy law, making things better for landlords too. We're going to look at the rights and responsibilities of both parties. I am convinced that this document, the residential tenancy law, when we publish it, it's going to surprise a lot of people and it's going to be welcomed by people. I think it's going to be very reasonable. There's going to be new things in there, and we're working our hardest to ensure that that happens. And I'm absolutely convinced that we are on the right road with a fantastic team that I've got working on it. So what can I say? The Assembly has to really it boils down to this: the Assembly having to judge the risk here. Senator Mezek may be right, and all the landlords will behave absolutely brilliantly. They'll understand. We'll slam this in, no consultation, and it'll all be fine. Or my suspicions that this is going to cause trouble for people, and are come to pass. I am not. I just think it's not a risk worth taking when we are going to do this. Probably this time next year or sooner if we can, we are going to do this and try to get tenants who've been there a long time to stay. We're going to do this, but we're going to do it properly, and we're not going to poke the bear and get, you know, the reaction that you get when you do get that. Because who's going to suffer? Vulnerable tenants. I think I've made my point, and I don't think I can continue. I could pick up on some technical issues, but sir, I maintain the amendment and I ask for the appel.
Well, the appel is called for, and I ask the greffier to put a voting link into the chat. And I open the voting and ask members to vote. The vote is on the amendment lodged by the Minister for Housing and Communities. Members have had the opportunity of casting their votes.
So could I cast a vote pour? I can't join.
Yes.
So can you have a bit more time, please?
Yes, if there's some difficulty, we'll give it another half a minute or so.
All good, thank you, sir.
Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The amendment has been adopted. 33 votes pour, 11 votes contre, no abstentions in the link, and a further 1 vote pour in the chat.
The 11, please, sir.
Yes.
Those members voting contre: Senator Valois, Senator Mezek, Deputy Ward, Deputy Higgins, Senator Moore, Deputy Pershard, Deputy Doublé, Deputy Southern, Deputy Tadier, Deputy St John, Deputy Alves. That's it.
Well, the debate on the proposition as amended is now open. Does any member wish to speak on the proposition? If no member wishes to speak on the proposition as amended, if I close any debate, it goes straight to the vote. Very well. If no other member or no member wishes to speak, then I close the debate and ask the greffier to put a vote into the link. I open the voting and ask members to vote. If members have had the opportunity of casting their votes, then I close the voting. The proposition as amended has been adopted. 39 votes pour, 6 votes contre, no abstention in the link, and a further 1 vote pour noted in the chat.
Have the conch, please, sir.
Yes, of course.
Those members voting contre the Conotab of St Clement, Senator Valois, Deputy Higgins, Deputy Guida, Deputy Trinity, the Conotab of St Mary.
Well, the final item of public business is.
Sorry, I did have a point of order. It might be slightly late, but and I don't know if I missed it, but did any member declare an interest? So any member who's got is a landlord with periodic tenancy, would it be necessary for them?
I'm sorry, it is far too late. I think the vote's taken, the matter is now closed, and we have to move on to the next item. Very well. We now come on to the final item of public business, which is amendment to standing orders, miscellaneous amendments, P3, lodged by the Privileges and Procedures Committee, and I ask the greffier to read the proposition.
The states are asked to decide whether they are of opinion to make the following amendments to the standing orders of the States of Jersey with immediate effect.
Deputy Alves.
Thank you, sir. These amendments to standing orders address a number of minor inconsistencies that have been identified by PPC following a review by the State's GREF. I note the comments from the Corporate Services Scrutiny Panel on these amendments, and I welcome the panel's general support and thank it for its work. I will run through the amendments in the order that they are set out in the proposition, but I'm happy to take a vote on each one if members would prefer. The first amendment is in relation to lodging amendments during the election period. In adopting the proposition, the States of Jersey elections, pre-election procedures for states meetings and the lodging of propositions P88 of 2018, the Assembly agreed that propositions should not be lodged during the election period as defined in standing orders. Effectively, this will mean propositions cannot be lodged from early March 2022, unless it is the bailiff's opinion that the proposition relates to a matter of such urgency and public importance that its lodging should not be delayed. P88 of 2018 explicitly stated that amendments should be excluded from this prohibition on lodging. However, this was inadvertently missed when the resulting amendment to Standing Order 19A was debated and approved. Without the amendment proposed today, it would not be possible to lodge amendments after the deadline to propositions listed for debate during the meetings of March and April of 2022 this year, unless it could be shown that they related to matters of public importance. This would not reflect the Assembly's will in adopting P88 2018, and therefore PPC has proposed this amendment. The second is in relation to propositions that effectively seek a vote of no confidence. Standing Order 22 sets out additional requirements for a proposition seeking a vote of no confidence in a person or body of persons. The proposition needs to be signed by 3 other elected members, and the report must set out why the proposer believes the proposition should be adopted. In December 2020, the Assembly debated draft amendment number 49 of the Standing Orders of the States of Jersey, P143 of 2020, which sought to ensure that the chairs of scrutiny panels could not belong to the same political party as any minister scrutinised by their scrutiny panel. As the proposition, if adopted, would have taken immediate effect, we highlighted in our comments that there was no need for the proposition to meet the requirements of Standing Order 22, even though its adoption would have seen an existing chair removed from that position. We highlighted that we would consider whether an amendment to Standing Orders should be lodged to deal with this procedural loophole. Therefore, we are proposing an amendment to Standing Order 22 to ensure that it would apply not only to propositions explicitly seeking a vote of no confidence, but also to propositions where the effect of their adoption would be tantamount to a vote of no confidence. The third is in relation to an outdated reference to subordinate legislation. Standing Order 37 sets out the process for the presentation of documents to the states. Paragraph 6 of this standing order specifies that it does not apply to ministerial orders, as the process whereby they are tabled before the Assembly is different. At present, reference is made in paragraph 6 to the subordinate legislation Jersey Law 1960. However, that law was annulled with the adoption of legislation Jersey Law 2021, and the reference in standing order therefore needs to be updated. The fourth is in relation of parental responsibilities. The Assembly has already agreed that parental responsibilities should be included as a reason for members' absence at roll call. When the amendment to standing orders was agreed to incorporate this principle, there was no consequential amendment to paragraph 4 to ensure clarity that a member absent for that reason would not be marked on defo. Therefore, we are proposing this amendment to ensure consistency within Standing Order 53. The fifth relates to propositions which may be taken in the proposer's absence. The provisions of Standing Order 71A, that's 70 bracket 1A, allow for an amendment to be proposed in the absence of the proposer, for example, through illness. But Standing Order 68 brackets 5 allows for a substantive proposition to be moved by another member if the proposer is to be absent and has given sufficient notice and is not marked on defo. Given the interpretive provisions of standing orders, Standing Order 68 brackets 5 in fact applies automatically to amendments as well as substantive propositions. Therefore, we propose to delete Standing Order 70 bracket 1A, which is superfluous as it effectively duplicates the provision of Standing Order 68 bracket 5. The sixth relates to the chair of the Planning Committee. Standing Orders 90 to 96 govern the arrangements for voting in the Assembly, including for appointments to the principal officers as defined in Standing Order 89AA. For instance, they allow for the electronic voting system to be used during the appointment of members to those principal officers, depending on the number of candidates. As the chair of the Planning Committee is currently excluded from the list of principal officers, however, an appointment to that position is not covered by the provisions of Standing Orders 90 to 96 in the same way, and it could therefore be argued that the electronic voting system could not be used for that appointment in the same way. This amendment would rectify that. The seventh relates to votes of censure against bodies. It became apparent recently that there is no explicit provision in standing order for the chair of a body subject to a vote of censure to speak a second time before the debate concludes. When Senator Mezek lodged a vote of censure against the Council of Ministers, the bailiff ruled that the Chief Minister had that right to speak a second time to ensure consistency with the provisions of censure relating to an individual and with the provisions for votes of no confidence. The amendment addresses this issue and ensures the right of the chair to speak for a second time is enshrined in standing orders. The eighth and final amendment relates to substantive speeches during nominations for appointment. It has recently become more common for members when nominating or seconding others for appointments to a position may be inclined to make a speech in support of their proposed candidate. This was not the previous convention when no speeches were made, but there is no explicit provision within standing orders. This could make it problematic for the presiding officer to manage the situation in extremes where a lengthy speech were made during nomination. Therefore, we propose this amendment to clarify that nomination or seconding should not be made the pretext for a speech. I move the proposition. Thank you, sir.
Are the proposition seconded? Does any member wish to speak on the proposition? Or if no member wishes to speak on the Deputy Tadier?
Thank you, sir. It's an observation on the rule about not lodging. Well, this is a lodging amendments during the election period. It's just to say that, of course, I understand that the motivation and the rationale for members not lodging fresh business just in an election period is presumably on the one hand to prevent electioneering, and secondly so that it can be dealt with in this term of the Assembly. I presume it's mostly the latter. Maybe the chair can clarify that, but of course if it is the former as well, that there is a mechanism whereby a member can lodge propositions and amendments before the cut-off period and without taking them for debate. So it's entirely possible to lodge something now, but decide that you don't want it to be debated until the new Assembly. And of course, if you're there to take it, all the better for you, and it can be used to publicise right up until the election. So I was wondering if the chair had any thoughts on that. I don't know if it's directly relevant to that First Amendment. Maybe it is. Just to know what her thoughts are on that, and whether we should give consideration to actually propositions which haven't been debated for whatever reason. It could be that they're timed out, that they should fall away if they haven't been debated before the cut-off period of the last sitting.
Thank you very much, Deputy. Does any other member wish to speak on the proposition? No other member wishes to speak on the proposition? Then I close the debate and call upon the Chair of PPC to respond.
Thank you, sir, and I thank Deputy Tadia for his contribution there. It is to limit electioneering that there is a cut-off point for lodging. However, propositions will not hang over. Anything which is for debate that has not been concluded by the end of the current Assembly will have to be withdrawn. That provision is already there. It's under Standing Orders 37 brackets 4. Sorry, 34 brackets 4. So I hope that addresses his concerns. I see that nobody has stated that they want a vote on each individual thing, so we can take it all together, please, sir. Thank you.
Yes, as no one's asked for it to be taken separately, it is within the decision of the Chair of PPC to determine how this is taken. Accordingly, the vote will be for the entirety of the proposition, all of the paragraphs, and I ask the greffier to place a link into the chat. I open the voting and ask members to vote. If members have had the opportunity of casting their votes, I ask the greffier to close the voting. Proposition has been adopted. 39 votes pour, no votes contre, no abstentions in the link, and a further 2 votes noted pour within the chat. That concludes public business, and I invite the Chair of PPC to propose the arrangements for public business for future meetings. Everybody else.
Thank you, sir. So there's been an update to the arrangement for public business for future meetings. The following has been lodged since the publication of the consolidated order paper, and both have been listed for the 29th of March 2022. That is the Rate Appeal Board appointment of members P16 2022, and the amendment to standing orders inclusion of Island Identity Statement P17 2022. It's also been noted in the consolidated paper, sir, that I would like to reduce the lodging period for standing orders for P15 draft public elections donations to public parties threshold. Jersey regulations which PPC lodged on the 4th of February, and I'd like to seek the Assembly's agreement to it being listed for debate on the 1st of March. I'd like to just take this opportunity to apologise to the Assembly for the late lodging of this, but it was out of our control as the threshold levels had to be determined by the Jersey Election Authority, which only came into being on the 1st of February and met for the first time on the 2nd of February. At present, no threshold exists, and therefore parties are not required to declare any donations they receive. As the regulated period for election expenses is to be submitted commences on the 22nd of February, it's really quite important and imperative that this limit is set as soon as possible.
So are you asking, Chair, for the Assembly's agreement at this point to take this proposition on the 1st of March or indeed during that sitting, or are you simply giving notice that you will make the application?
I'd like to do that now, sir, to give members sufficient notice.
Very well. Do you wish to speak further, or have you?
No, that's it, sir. Thank you.
Is that proposition seconded to take P15
Yes, sir.
next at the next sitting?
Yes, sir.
Very well. Connacht Arbison 1, I see you wanted to speak, but that was before, I think. Is that on this particular proposition, taking P15 early?
No, it's not, sir.
Very well. Well, Connacht Arbison Brillard?
Not on this part, sir.
Very well. Connacht Arbor Grouville?
Yes, I'd like to ask a question. If we bring in limits later on after March and political parties have received donations before then, what happens?
I mean, it may be that the chair is able to assist you with that information. Personally, I haven't read the statute other than to approve it, so I haven't received the detail. Does any other member wish to speak on this proposition to bring on P15 early? Allow it to be debated on the 1st of March sitting. No other members to speak. Chair of PPC, would you like to respond?
Sure, thank you, sir. So at the moment, as it stands, all election expenses start as of February the 22nd of this year. So parties would have to declare that any expenses from February the 22nd this year. I hope that clarifies things for the constable.
Did you have, does that assist you at all, Connacht?
It doesn't completely answer the question, sir, because people won't know what those limits will be before the date that it's set. So in theory, if the start date of expenses is the 22nd of February, no limits have been set until well into March. There could be a problem, I see, but I don't know the answer.
Yes.
Oh, okay. Yes, I see, sir. So obviously the limits are in the proposition for the parties. This does apply to independents. So if it's not passed, then it would default to the independent limit.
Very well. Well, I think that's probably as given this is only, are we dealing with it on the next occasion? That's probably as far as reasonably we can go. I'm going to take this on a standing vote unless anyone wishes the appel or anything of that nature. All those in favour of taking this early? I'll assume that anyone who indicates that they are against it will now say so in the chat, because if everyone simply puts in that they're in favour, I'll assume those in the chat are in favour unless people a large number indicate a contrary view. No, in which case that's taken on a standing vote. That will be dealt with on the next occasion. Now, Connacht Arbison 1, you wish to speak on the arrangements for future business, I think?
I do, please, sir. Could I crave the indulgence of the Assembly and ask that P12 and P10 be taken as the first item of business at the next sitting, please, sir? This relates to the debate on the new canons for the Church of England, and it's to give the Dean the opportunity to be present on that day, which if it moved into other days, he might not. There's a very good chance he wouldn't be able to be there, which would be unfortunate, I think.
Well, is that proposition seconded? Anyone wish to speak on that proposition? No member wishes to speak on the proposition, then I will take that as a standing vote as well, that P10 and P12 will be dealt as the first two items of business on the 1st of March. If anyone wishes to indicate, well, anyone in favour, please stand, or very well, thank you. Anyone against? If they would indicate a contrary intention in the chat, please. No contrary intention in the chat. And accordingly, that is passed on a standing vote. Conitard of St Brelade.
Thank you, sir. Just to ask the leave of the Assembly, I've advised the GREF that I wish to withdraw my amendments 53, 54, 55 and 56 of P36.
So 53, so I've got to look through and find these. 53. Yes, so 53, your 4 amendments there, you're withdrawing, Conitard.
53, 54, 55 and 56, sir.
Yes. In fact, you don't, I think it's a matter of courtesy to notify that to the Assembly, but you don't require leave to withdraw them, and they are taken as withdrawn then.
Thank you, sir. Do
you propose the arrangements for future business as the Assembly's now got it under consideration, Chair of PPC?
Yes, please, sir. I think Deputy Young would like to speak.
Deputy Young, yes.
Yes, so just as a courtesy, obviously, we're going on the order paper, which lists up to amendment on the island plan for the 14th of March, up to number 79. I think the latest we're actually at 86 now, and I hate to add to the volume of business, but it is my intention to pull together some consolidating amendments which I need to do as a minister. So I think just to note that that list will become rather larger, and of course amendments under the rules we passed, members do have the opportunity to amend their own amendments. So I just think that should be noted. So thank you.
So when you indicate you're going to put in a consolidated amendment, does that mean that will make it clear?
Yes, sir.
Whether or not you will be accepting the amendment, or
yes, a number of consolidating amendments which will follow on from the commitments that I gave in my response to the inspector's report to indicate to members which ones of the amendments were likely to be supported and those which were not, and those which needed amendment. And so those consolidated amendments are well advanced and can be expected to be there shortly. I'm hopeful that will help the debate, so thank you.
Thank you very much for notifying members of that. Conitard of St Juan, you have something to add?
Yes, I'm sorry to come back, so I just want to clarify something. I may have got this wrong. I'm not particularly clear at the moment whether the Ordering Council and the adoption of the new canons needs to come before the draft ecclesiastical legislation. But given that the Assembly very kindly agreed to let me take both those items at the start of business, could I clarify with PPC which ones I need to take first to make sure we get it in the right order?
I'm sure the Assembly would be entirely content to ensure you get them in the right order from a procedural point of view, Conitard.
Thank you, sir.
Sorry, do you have something you wanted to say? Very well. Once again, the Chair of PPC, you propose the order for businesses has now been articulated by members.
Yes, please, sir. I propose the public business. Thank you.
Very well. Is that seconded? And does any member wish? Does any member wish to oppose? Very well. That concludes the matter for the Assembly, and we stand adjourned until Tuesday, the 1st of March.